Hello, everybody, and welcome to today's installment of our ENSafrica Banking and Finance webinar series. For those who are joining us for the first time today, my name is Jessica Blumenthal, and I'm a director in the Banking and Finance Department practicing in Cape Town. This year, we decided to present our webinar series with an ESG theme. We call it the ESG edition. And I think you should see on your screen now the different webinars making up the series, arranged under the E, the S, and the G. The webinars in this series are presented by members of our ESG practice group, which is a group within the firm made up of our experts from all different departments within the firm. Today, you'll be hearing from Mkhlali Stefani and Dalit Anstey from our Natural Resources and Environment Department, and Alex Taylor from our Banking and Finance Department. And they'll be speaking to you about the liability for lenders to an environmental disaster. But you'll see from the webinars reflected on the screen that we've got a lot of different topics, all relevant to the financial services industry, as the intention of this webinar series is to give back to the industry in which we worked, particularly as a banking and finance department. And for that reason, these webinars are all accredited for continuous professional development hours. So by attending this webinar, you can earn a certificate for 1 CPD hour. But please do remember that in order to be eligible for that certificate, you need to stay online for the duration of the webinar. We're only able to issue certificates to those who have been in attendance for the full hour. In addition to giving back and to adding value to the industry, we also, of course, want to stimulate debate and share some of our experts' thought leadership with you on very important topics that fit in under the ESG umbrella. And it's really in that vein that the various topics for the webinar series were devised. So I don't want to take up too much time from our presenters, so I'm going to hand over to them. Please remember that you can ask questions, which the presenters will deal with at the end of the session. You can use the Q&A block, which you can see at the bottom of your screen, to load your questions, and Mkhlali, Dalit, or Alex will answer your questions at the end of the series. Thank you very much again for joining us, and we hope that you all learned something new today. Thank you. Mkhlali, over to you.
Thank you so much, Jess. I'm just going to wait for Alex to put up our presentation. And while she does that, again, like Jess said, my name is Mkhlali Stefani, and I am in the Natural Resources and Environment Department. I'm joined by my colleague, Dalit Anstey, in the same department, together with Alex, who's in the Banking and Finance Department. So our presentation today really is about liability for lenders to an environmental disaster. And just as a background, historically, lenders have been mainly concerned with the borrower's ability to service the debt and the indirect environmental risks relating to existing liabilities and non-compliances. However, recent developments in environmental law and finance have seen a growing emphasis on the potential liability of a lender for environmental harm caused by the borrower. And so the rise of ESG makes it essential for lenders to be aware of lender liability in the context of environmental law. Alex, you can move to the next slide. And that's our beautiful team. And now, as an overview, we'll be looking at environmental law broadly, and then we'll be looking at lender liability in South African context of environmental law. We'll then consider international precedents and what international trends are showing us. And then we'll close with fiduciary duties with respect to the environment before we tie it up with some of our key takeaways for the session. So we hope you enjoy it. Next slide. So environmental law basically is important to understand. Well, it's important to understand environmental law broadly before we can zone in on it from a finance perspective. Environmental law is concerned with the impacts of an activity and how such activity can be done in a lawful manner. And the impacts are looked at from how the activity impacts land, water, microorganisms, and plant and animal life, and air. Next slide. And why does environmental law even matter? Some people might ask. Well, the new democratic government brought a different approach to development. The agenda focused on placing the interests of people first, involving people in decision-making, and ensuring sustainable development, meaning that we're using resources with the future generations in mind. Next. And so this is really anchored by our Constitution, and this is the source of the environmental right. Section 24 of the Constitution anchors why environmental law matters in this democratic era we're in. And it provides that everyone has a right to an environment that is not harmful to their health or well-being. And secondly, to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures that, 1, prevent pollution and ecological degradation, 2, promote conservation, and 3, secure ecologically sustainable development and the use of natural resources. Next. And so where this really comes from, this entire discussion about lender liability, it really stems from what we call NEMA. And NEMA is basically short form for the National Environmental Management Act, which is the framework legislation regulating environmental law in South Africa. And more specifically, Section 28 of NEMA provides us with the duty of care. And we'll see as we progress through the discussions how this duty of care has an impact in the discussion around lender liability. And so you might be asking yourself, so what is this duty of care? So Section 28 of NEMA says, and places the duty of care not only on the owner or controller of the land, but also the person who has the right to use the land, a person who has caused significant pollution or degradation of the environment, or a person who undertakes an activity which causes or is likely to cause significant pollution and degradation of the environment. And such a person is required to take reasonable measures to, number 1, prevent such pollution or degradation from occurring, continuing, recurring, insofar as the harm to the environment is authorized by law or cannot be avoided or stopped, or to minimize and rectify the pollution or degradation. And so you can see from this provision that our law actually recognizes that impacts will occur, but the duty of care requires that such impacts are either prevented, and if not, they need to be minimized or rectified in an authorized fashion. Next. And there's a consequence, right, to this duty of care, and a failure to do that, and a failure to remedy the pollution, or failing to comply with a directive where the authorities actually issue you with a directive, then it's an offense upon conviction, and you could be liable for a fine not exceeding 10 million, or imprisonment, or both. And so we can see that this is incredibly serious. And secondly, criminal proceedings may also be instituted over and above this in the context of environmental law. So now, zoning in specifically on today's topic, we'll be looking at lender liability in this context. So up front, we need to state that no environmental legislation in South Africa that specifically deals with the issue of lender liability. Nevertheless, there are statutory duties which make it possible for a lender to be held liable for the environmental impacts of a borrower's activity. The risk of exposure is determined by the lender's degree of control over the borrower. And you might be asking yourself, what control? And our control might be established in various ways. And here's some helpful itemized pointers. Control can be established through contractual terms and the structuring in financing agreements. That's one way. Another way is through majority shareholding. Thirdly, the power to appoint and control a board through the appointment of nominee directors or any other form of control which may be recognized by the courts. Control could also be established through the ownership of property. And lastly, the use of property. Again, this is not a closed list, but this is some of the items that can be looked to establish whether or not the lender had control over the borrower. So the duty of care that we discussed earlier in section 28 of NEMA is not limited by the corporate veil, which is what you'd expect in a normal corporate environment. In fact, the corporate veil, in terms of the corporate veil, liability may be attributed to a person who misuses or abuses the principal or corporate personality, thereby attributing the company's rights and or obligations to them personally. This construct disregards the separate legal personality of a company. The statutory duty of care permits the court to take into account who the holders or the directors of a company are, and to have regard to the shareholding in the company for some legal purposes, in this instance, for ascertaining environmental liability. So an equity lender, then after everything we've discussed, may attract liability as a result of their relationship to the land and may be viewed as being in control of the relevant land in circumstances where it is the majority shareholder in the relevant operational entity. In a debt finance scenario, a lender may be viewed as being in control of the relevant borrower where it exercises its rights in a default scenario and where it takes up majority shareholding in the entity or that owns the land, or in circumstances where it exercises its rights in terms of the applicable collateral over the land. And in this case, liability may be imposed on the lender as if it was the owner. Similarly, if the lender participated in the management of the borrower, and this might also attract liability. And again, lenders may also be identified as entities which benefited from the remediation measures of these borrowers who negligently failed to prevent pollution or degradation. So in addition to NEMA, we've also got the National Water Act. And in the context of environmental law, the duty of care appears in various pieces of legislation. So NEMA, like I said initially, is the framework legislation, but we've also got the Waste Act. And a lender could also be held liable for contaminated land in terms of the Waste Act. The Act contemplates holding only the owner, for example, an occupier or someone in possession of the land, and the actual polluter liable, and only in relation to areas which have been formally made investigation areas and remediation sites. If the lender is the directing mind of the borrower or has a degree of control thereover, it is possible that it may be liable as the polluter insofar as it had control over the measures to prevent and had a duty to prevent the pollution. Similarly, in the case of a default scenario and the lender takes transfer of the contaminated land, there's also exposure. Although there are no South African cases of lender liability for environmental harm, there are some instructive international law examples of situations where the courts have considered the question of control and lender liability. And I will now hand over to my colleague, Dalit, who will then be looking at these international precedents.
Thank you so much, Mihlali, and thank you all for attending this seminar on a very, very important topic. So I will be talking about the international precedents on lender liability. As Mihlali correctly pointed out, there are currently no South African cases, but international law has persuasive value in South Africa. It's indicative of where litigation and strategic litigation trends are going. And yeah, so it has kind of an indirect effect on South African cases, and obviously also where we have international obligations, it could have a more kind of direct effect. Next slide, please. So I think before we go into some specific tangible cases which illustrate how lenders have been held liable, I just wanted to talk about some of the general points and themes before we go into the specifics. So there's been a bit of a paradigm shift in international law. As a starters, many years ago, there was just probably very little lender liability, but now we're starting to see both direct and indirect forms of lender liability. So the American cases, which I'm going to talk about, kind of go to these more direct forms of lender liability. And then what I've referred to as indirect liability through subsidiaries is also known as parent liability. And that kind of trend has been quite prominent in the EU and the UK. And the courts in those cases have been prepared to pierce the corporate veil. So some of the themes that emerge from the cases are with respect to procedural matters. So what we find in these cases is that the cases take a turn where they deal with extensively on procedural matters, and these procedural matters can take years to finalize. So an example of a kind of procedural matter that I'm talking about is the jurisdictional issues that arise. So what I mean by that is founding jurisdiction in a country where the lender is situated by persons or victims of the environmental disaster where the harm has actually occurred. So obviously, where you're dealing with, for instance, an example of parent liability, you know, the parent might be in the UK, but the subsidiary who actually who committed the harm or the alleged harm is in Nigeria or South Africa. And so the question is how to actually get a court in the UK to look at this case where the harm actually occurred in South Africa. Another theme that arises from the cases is this theme of duty of care, which Mihlali has spoken about in the context of South African environmental duty or duty of care to the environment. But here we have these cases that are brought commonly under the principle against a parent's company, and that's where the parent is a majority shareholder in the subsidiary. I'll go more into that as we look at the cases. Then, very importantly, we have the issue of control, which is where the cases turn on how much control the lender has vis-a-vis the borrower. And something that I think is important to think about throughout is that, on the one hand, lenders need to have a degree of control, and that what that requires, and what the case law is kind of saying is that, in fact, the lender has control, and therefore the lender should be required to actually take more active steps to ensure that that control is conducted responsibly. But on the other hand, there's a perverse effect that lenders might wish to have less control in order to avoid liability. And that's something that I'll talk about a bit later, but I think that it's a balance. And I think what I was saying about it being lenders are actually already in control. And so that's what the courts are actually referring to in these cases. But we'll see as we go along now. Next slide, please. So the first case that I want to turn to is Friends of the Earth and a number of other NGOs in America versus Robert Mosbacher. And this, as I say, is an American case. The facts of the case are that these various NGOs charge that the administration's Export-Import Bank and Overseas Private Investment Corporation provided more than $32 billion in financial assistance to oil and other fossil fuel projects without first evaluating the project's global warming impacts to the United States. So the issue for determination was, does the National Environmental Policy Act apply to major federal government projects that contribute to climate change? Next slide, please. So the decision in this case was important. The court held that it must look to whether an agency that provides financing to a project can influence or does possess actual power to control non-federal activity. The court examined whether the defendants had any decision-making authority
Jessica, I'm not hearing Dalit on my side. Can you hear her? Okay. So should we do that? Right. So just while we give Dalit a moment to reconnect, I think she's had a slight internet difficulty. Just checking that you can hear me, Jen. Oh, Dalit, are you back?
Yeah, I just got kicked out of Zoom. I pressed nothing, so.
Oh dear, I was about to jump to my section, but no problem. You can pick up where you left off.
Can you hear me?
Yeah, we can hear you. Can you hear us?
Okay, sorry about that.
Perfect.
Yes, so yeah, that was the right side. Sorry about that. So I was just saying that it's a small thing, like the kind of language that you use in a contract, that in this case persuaded the court to agree with the plaintiffs that the lender actually did exercise control. Then there was another bank, Ex-Im Bank. The court held that Ex-Im Bank was empowered by statute to withhold financing from a project for environmental reasons. And this, the court said, was indicative of Ex-Im being able to have, to exercise influence, thus giving them decision-making authority. But there was a further test there that the court developed and said that if the level of financing would not would, I need to amend that slide for purposes of distribution, but it's if the level of financing would not impact the project's operations, or if the applicants could have found financing elsewhere, the court cannot say the conditions imposed to receive financing would give the defendant sufficient control and responsibility. And with respect to that bank, the court held that the projects were not primarily funded by that defendant. And so therefore that defendant was not held liable. But next slide, please. Importantly, the court also rejected two key government arguments, which I also just wanted to address. These kinds of arguments are quite common. So one of the issues that the government raised was that because the challenge projects fell outside of the US and that the impacts of global warming on the US environment are too remote and speculative to be considered, the court rejected those two arguments. And whilst this is not determinative of whether liability will be imposed, it provides a useful example of the considerations relevant to whether the lender is seen to have sufficient control over the borrower. But at the end of the day, it will always depend on a case-by-case and factual basis. Next slide, please. The next case that I'm going to talk about is a very famous case known as Vedanta versus Longowe. Next slide, please. So I think I'll just take you through the facts and the parties to this case. So the litigation arose from the alleged toxic emissions from the Nchanga copper mine in the Chingola district of Zambia. The claimants were approximately, just under 2,000 Zambian citizens who lived in 4 communities within the district. They are poor members of a nearby farming community that were reliant on watercourses for drinking, irrigation, and livestock watering that were polluted by the mine over 15 years. The copper mine is actually the second largest copper mine in the world. The mine is owned by KCM, a company registered in Zambia. And KCM is a significant company within Zambia. The other defendant was the parent company, Vedanta Resources, which is the parent company of KCM. And it is also a massive company in its own right. Next slide, please. So the nature of the claim against KCM and Vedanta was based on common law negligence and a breach of a statutory duty. A claim was brought against KCM because it was the owner of the mine, and against Vedanta because it was in effective control of the mine and was in control of KCM's compliance with applicable occupational health and safety and environmental laws. The claimant sought compensation for personal injury, property damage, loss of income and amenity, and enjoyment of land because of pollution from the copper mine. Next slide, please. So the claimants brought their case in terms of these relevant legislation in the UK. But what happened almost immediately when they started to bring a substantive case, the defendants applied in kind of an interlocutory manner, which is an intervening step in litigation to challenge the jurisdiction in the UK. This challenge was dismissed in 2016. And then the defendants again appealed the decision in 2017, and again their challenge on jurisdiction was dismissed. This led ultimately to the proceedings in the Supreme Court in 2019, where the Supreme Court confirmed that UK parent companies can be held liable for the actions of their offshore subsidiaries, and UK courts have jurisdiction to hear such claims. But it's very important to recognize that this appeal is only about jurisdiction. The appeal has allowed the farmers to proceed with their substantive claims that are yet to be heard in the UK. But what I will say as well that was important to the court was that the court felt that there was a real risk that justice would not be obtained if the court went ahead in the country in which the subsidiary operated in. So that's also one of the key reasons why it was prepared to hear the case. There's also another interesting point, and something that I will also talk about a bit later, but these parties actually settled in January 2021. So the claim will not go to the substantive merits, but the mere threat of the substantive merits being heard was enough to actually compel the parties to reach a settlement agreement. And I believe that that settlement agreement has gone ahead. Next slide, please. So the next case that I'm going to talk about is two cases actually involving Shell. Very similar set of facts. The one was in the UK and the one was in the Netherlands. This is where they were heard. But both set of facts arise in Nigeria. So this is now the UK case, Okabi versus Shell. So various residents in the River State, Nigeria, filed proceedings against Royal Dutch Shell and its Nigerian subsidiary SPDC, holding both companies liable for environmental damage caused by oil spills from pipelines and infrastructure operated by the subsidiary, which resulted in contamination of water sources without remediation, therefore rendering the water sources unsafe for drinking, fishing, agriculture, washing, or recreational purposes. So I thought I'd also just take you through some of the arguments in this case. So the SPDC, which is a subsidiary company, was not domiciled in the UK. The claimants needed to establish the jurisdiction of the English courts and prove that they had at least an arguable claim against RDS. The claimants argued that the oil spills were the result of negligent pipeline maintenance and oil spill response by SPDC. The claimants also argued that RDS owed them a duty of care at common law as it exercised significant control and direction over its subsidiary, amongst other things, by promulgating, monitoring, and enforcing group-wide health, safety, and environmental policies and standards. We see this very often where companies have group-wide environmental policies and health and safety policies. So the claimants relied on Vedanta, the previous case that I addressed, which held that in the context of parent-subsidiary relationships, whether a duty of care arises depends on the extent to which and the way in which the parent availed itself of the opportunity to supervise or control the subsidiary. Additionally, the claimants argued that they could not expect justice in a Nigerian court. So very similar arguments made. Yeah, thank you. So the respondents contended that the facts relied upon did not demonstrate the exercise of direction, control, and oversight by the parent company, and that all relevant operational decisions were made by SPDC. So the parent company was saying, yes, we made these policies, but at the end of the day, operationalizing these policies is the responsibility and in fact is done by the subsidiary company. The respondents also argued that the subsidiary was responsible for its own operations, including the implementation of the group-wide standards, and that the subsidiary was better placed than the parent company to deal with the alleged harm because the subsidiary possessed superior knowledge and experience regarding oil operations in Nigeria. The respondents also argued that SPDC was a major operating company in and of its own right and was financially independent, and that RDS, the parent company, did not have oversight of the day-to-day activities of the subsidiary. Next slide, please. So the decision was that, so the Supreme Court held that there is no limiting principle that a parent could never incur a duty of care in respect of the activities of a subsidiary merely by laying down group-wide policies. Just to clarify, the parent company here tried to almost rely on a defense that they had created these policies, but that was all that they were required to do, and they weren't responsible for the implementation of them. So it's a complicated, nuanced argument, but they're almost using it as a defense. But the court was saying that even in these circumstances, such policies could indicate that a duty of care existed if the parent, basically they were saying that they tried to discharge their duty of care. So the court was saying that if the parent took active steps to implement the policy, or the parent held itself out as exercising the relevant level of control, supervision of the subsidiaries pursuant to such policies, irrespective of whether it in fact did so. To the extent that such policies apply to inherently dangerous activities, the court confirmed that a parent might be held liable in respect of harm arising from systemic failures in those policies. So the Supreme Court also held that the actual control inquiry was just a starting point, and the relevant inquiry was the extent to which the parent did take over or share with the subsidiary management of the relevant activity. So again, a very factual inquiry. The court observed that control of a company and de facto management of a part of its activities are two different things. So on this basis, the Supreme Court held that it was least arguable, based on the degree of control and de facto management, that the parent company owed a duty of care to the claimants in respect of the alleged environmental damage and human rights abuses by SPDC. Okay, next slide, please. So linked to this case was a very similar case brought in the Netherlands, also against Shell. And so the Nigerian farmers here made 3 claims supported by an NGO regarding 3 separate oil spills from Shell-operated pipelines and wellheads in certain villages in Nigeria. Like in Okabi, the farmers alleged that their primary farmlands and fishing grounds were contaminated by SPDC and RDS. The claimants sued both RDS and SPDC as co-defendants, alleging that the spills were caused by the negligent maintenance of the defendants and resulted in extensive damage. The defendants denied the allegations, arguing that the spills were caused by sabotage, and in any event that they had adequately responded to the environmental disaster by switching off the pipelines. So they tried to argue that they had acted reasonably in the circumstances. Next slide, please. So in this case, the court held that with respect to 2 of the 3 claims, the subsidiary was subject to strict liability under Nigerian statutory law for damage resulting from the oil spills. The only defense to prove against the strict liability would be to prove that beyond a reasonable doubt that the spills were caused by criminal acts like sabotage, which the defendants had not demonstrated. The court also found that the subsidiary's responses to the spills were negligent and ruled that the installation of a lead detection system, LDS, would have enabled the defendants to shut off the pipelines to stop the spills earlier. Since the subsidiary's liability was partly based on Nigerian statutory law, the court ruled that the parent company could not incur duty of care to the claimants for that part of the conduct. However, the court found that following its active intervention, now this is the parent company's active intervention with the subsidiary after 2011, RDS had a duty of care towards the claimants to ensure the installation of the LDS, this lead detection system. Other claims against, including the negligence claim against RDS regarding the cause of the spill and the claims regarding the inadequate cleanup measures, were rejected. Next slide, please. So let's just maybe take out some key points or lessons from these 2 cases. So the main route that the victims used to hold parent companies liable in both cases was through common law negligence claims. I think it's also important to ask, so why pursue the parent company or lender as opposed to the subsidiary? And in these cases, arguably, the remedy was more effective for the victims. And so regardless of whether it's financial reasons, perhaps the subsidiary is a man of straw, perhaps there's political reasons, for some reason, a case wouldn't be successful in a particular court because of political connections, or even legal reasons. In some jurisdictions, there is no justice in a legal system. And so in a way, going through with the whole judicial system is not worth it for the claimants. They want more kind of immediate redress. And I think the other important point is that the success of the procedural claim will often force the parties into a settlement. If the claim proceeds to the court to be decided on the merits, the claim will take years to resolve. And so actually in these cases, the victims, you know, maybe might be incentivized to enter into a settlement, but the very push or these jurisdictional issues actually lead the lender sometimes to, or the parent company, to settle. And I think the other thing is important with these cases is that they demonstrate the interrelated nature of voluntary standards and policies with legal obligations. So in Okabi, the voluntary standards and the policies adopted by the parent and subsidiary were ultimately utilized by the court to determine the control of the parent company over the subsidiary under its duty of care. So I think a lot of the time also corporates don't always pay attention to the real substance of those policies, but it's really important that they are taken care of at the highest level, perhaps even at a board of director level within a company. Next slide, please. Oh, and also just to mention, even just before the session, I saw that there's a similar case being made by 200,000. This is now the largest of these claims, victims of the Brazil's Mariana Dam collapse in UK courts, and that's being brought against BHP Billiton and various other parties. So I'm not going to take you through as much detail on this case as I would have liked for purposes of time. It's a very important case, this JAM versus the IFC, but we've actually drafted an article on it that will follow along with this presentation, the recording and the slideshow, where we actually explain this case in a lot of detail. But I think it is a very important case for purposes of where lender liability might go, because we are ultimately dealing with the IFC here, who is one of the most important lenders in the world today. So this case, JAM versus IFC, is, again, it's a USA case, and we have fishing communities and farmers who challenge the IFC for its role in funding and enabling the Tata Mundra ultra mega coal-fired power plant in Gujarat, India. The construction and operation of the 4,150 megawatt power plant along the Gujarati coast destroyed natural resources relied upon by generations of local families for fishing, farming, salt panning, and animal rearing. The difficulty with this case is even the legal route and strategy that the IFC took, because the IFC's own accountability mechanism, internal accountability mechanism, criticized the IFC for its role in the project. But the IFC actually ignored its own ombudsman, and the communities took the IFC to court. And it's one of the first times that this kind of an international financial institution is being directly taken to court for funding and enabling an allegedly harmful project. Now, again, this comes down to litigation strategy, but the IFC is not denied causing any harm. Instead, it has responded by arguing that it has complete immunity from suit. And again, this is another one of those kind of procedural matters that I spoke about earlier, because if you're immune from suit, it means you cannot be sued. And often international organizations and states is the classic example where holders of immunity, but often international organizations would rely on a form of immunity. And historically, that is exactly what the IFC and other kinds of international lenders would have relied on in order to prevent these kinds of claims, because you'd think, oh, maybe these kinds of claims would be common cause, but they're not actually. And this case might open the floodgates for further claims. So just in short, so in 2015, the plaintiffs sued the IFC in Washington, challenging that they had absolute immunity from suit. And you can go into the next slide, where you'll see that they actually were successful in that. The Supreme Court ruled that these organizations can be sued in cases where established exceptions to the immunity enjoyed by foreign nationals apply. Now things get very kind of litigious, as they always do, and things got a little bit, they get a little bit complicated. But the IFC, in the further litigation, filed a motion to dismiss the case, arguing that the exceptions to immunity did not apply, and they're simply that they're not responsible for the harm to the Indian communities. And this motion to dismiss was actually granted. You can go to the next slide. But what then the plaintiffs tried to do is, because they tried to show that the IFC took all relevant actions, including approving the loan from its headquarters in Washington. But the district court again dismissed this and found that regardless of whether the IFC's conduct was commercial activity, and this links to the exception that they tried to rely on to immunity, the plaintiffs, but the IFC's conduct was not what the suit is based on. So I think what's also interesting, just for purposes of our discussion, is the plaintiff's argument that the IFC was no ordinary lender and that it should be liable based on its alleged central control in setting environmental guidelines for the plant's performance. So obviously the DC court did not reach the merits, but its analysis does suggest some skepticism towards the plaintiff's theory that the asserted harms flowed from the lender's actions. Even crediting the allegation that the plant would not have been built without the IFC's funding, it reasoned the operation of the plant is what actually injured the plaintiffs, and the manner of its construction and operation is the crux of the complaint. So this kind of suggests that novel theories of lender liability are yet to gain traction in the US courts. So I think just finalizing this case, just to say that the battle's ongoing, and in January 2022, there was another petition to review with the Supreme Court. So I just want to thank you, and then I'm going to hand back to Mitlali.
Thank you so much, Dalit. Thank you so much, Dalit, for that insightful analysis. So now we'll be looking at fiduciary duties with respect to the environment, right? Next slide. What are the fiduciary duties in the context of the environment? I think that's the starting place, right? And these would include ESG disclosure and reporting, incorporating ESG into decision-making processes, and implementing strategies in relation to ESG, identifying ESG risks and risk management. And then who do the fiduciary duties sit with in respect to these ESG issues, particularly environmental issues that my colleague Dalit has dealt with in detail? And we'd like to look at, firstly, directors, prescribed officers, asset managers, and fund managers. Next. So the business and affairs of a company must be managed or under the direction of its board, and this is something we all know, which has the authority to exercise all of the powers and perform any of the functions of the company, except to the extent to which the Companies Act or the MOI would limit. Section 76, subsection 3 of the Companies Act states the fiduciary duties as requires actually rather that directors of a company, when acting in that capacity, they are to exercise their powers and functions in the best interest of the company in which they are appointed as directors. The lesson here for lenders is that lenders must ensure that the directors of a company of the borrower, or the borrower, are held responsible, and appropriate clauses and indemnity provisions are contained in such agreements. My colleague Alex will speak further to this. Next slide. Prescribed officers. Many of you perhaps at home or from the office who are watching wouldn't even know that in terms of the Companies Act, you would actually be classified as a prescribed officer. So there are indirect obligations to be placed on prescribed officers within a company. In recognition of the complexities of corporate decision-making, South African law has developed the concept of a prescribed officer, which encompasses employees who exercise or participate in the exercise of executive authority over the business affairs of a mining company or any company for that matter. And this would include chief executive officers, operating officers, the head of the operations, finance executives, company secretaries, general counsels, and everyone really who participates in executive decision-making. Depending on the company, this list can be extended to technical, legal, financial, sustainability, and other senior managers who practically are in charge with the various key portfolios of a company and whose knowledge and expertise are often determinative of the issues that the directors must resolve. And just from that brief explanation, you could see how many of you could actually become prescribed officers. So therefore, the role of prescribed officers cannot be underplayed because directors are entitled to rely on the performance of any person to whom the board may have reasonably delegated, informally or formally, the authority or duty to perform functions of the board, and information, opinions, recommendations, or statements which are prepared or presented by those employees of the company. Lenders must therefore ensure that suitable arrangements, again, contractually and otherwise, would guide the negotiation process and the borrower selection process. And ultimately, the contractual terms in these agreements must ensure that ESG-related risks are sufficiently mitigated and monitored. Next slide. I'll hand over to Dalit to take it forward.
Thanks, Mitlali. So I think asset managers and fund managers are another category of persons who owe fiduciary duties with respect to ESG obligations, and that can include environmental obligations. So Regulation 28 under Section 36 of the Pension Funds Act states that pension funds' fiduciary duties supports the adoption of a responsible investment approach to deploying capital into markets that will earn adequate risk-adjusted returns. It also states that prudent investing should consider factors which may materially affect sustainable long-term performance of a fund's assets, including factors of an ESG character. So the point is that asset managers owe a fiduciary duty to their clients to consider ESG factors as they impact the sustainability of long-term investments. And neglect of these ESG factors, which includes environmental factors, by an investor may lead to claims against the investor, especially where the investee is potentially a man of straw. And we might start to see replication of similar hard obligations in other pieces of legislation in the financial services sector. At least that's what the draft sustainable finance paper suggests. So just summing up what you've heard so far. So in terms of the key lessons, I think it's important just to recognize, this is now from Mitlali and my presentations, that lender liability remains a theoretical possibility in South Africa. There's growing recognition and growing international precedent to hold lenders liable, whether it be via parent liability or direct lender liability. But as we've also seen from the international cases, that there are many hurdles, and most of these are often jurisdictional hurdles. But given that a lender may be held liable for environmental impacts of a borrower's activity, it becomes critical to understand that the borrower's activity turns to a large extent on the decisions and the actions of its management, and including directors, executives, and prescribed officers. So this is one of the places where ESG risks lie. Where fiduciary duties lie, especially with respect to climate change and environmental compliance, lenders ought to familiarize themselves with such duties to ensure compliance by the borrower and to conduct appropriate due diligences. So I'm going to hand over to Alex.
Cool. Thanks so much, Mitlali and Dalit, for taking us through such an interesting presentation thus far. And hi to everyone who's joined us for this presentation. Thanks very much. So now we wanted to pause on a practical takeaway for all the funders and borrowers that have joined us for this session. Clearly, from what we've discussed and what Mitlali and Dalit have taken us through today, environmental factors faced by borrowers create real and theoretical risks for funders. And broadly, we can categorize these risks into two types of risks. Firstly, there's obviously the risk that environmental liabilities may threaten the profitability and solvency of the borrower themselves, and thus affect their ability to meet their obligations to funders under funding agreements. And secondly, there's this additional risk that we've been discussing and that Dalit took us through in the international case law that she reflected on, that lenders themselves may in fact be held liable for the environmental harms that have been caused by the borrowers that they fund. And certainly there's a growing international precedent and discussion around this. So Now we're going to reflect on what funders can do to protect themselves practically from these risks, and what provisions they can include in their legal agreements when negotiating these with borrowers in order to mitigate these concerns. As many of the bankers and other funders on the call may know, there is an emerging standard practice in the market to include environmental linked provisions into funding documents themselves to address the very issues which we've been discussing on this call today. And indeed, the Loan Market Association has now prescribed some language in this regard, which can serve as a starting point for negotiation with borrowers as to the mitigation of these risks. So, of course, it's always preferable for funders to include these types of provisions in every funding agreement that they conclude, but naturally, one should be especially careful to make sure that these risks are adequately addressed where you're dealing with a borrower whose business or their line of business is particularly risky from an environmental perspective. So when a lender is facing a borrower who's a mining house or perhaps a renewable energy producer or a borrower who runs many factories where there's risk of environmental harm, lenders should particularly prick their ears up in those instances to ensure that they've mitigated these risks. Right, so what are these provisions that we are in the market introducing into agreements to deal with these types of risks? So broadly, there are two categories of provisions that we include. The first category sort of deals with forward-looking early warning provisions, as it were, that can be introduced into agreements to deal with these risks before an actual loss arises. And then there's a second category of provision, which is a liability allocation provision that we would include where environmental loss has actually crystallized and been sustained. So the first category includes representations and undertakings by the borrower, and that would include, for example, that the borrower is in compliance at all times with environmental law, and that it has all the necessary environmental permits and authorizations in place from an environmental perspective to carry on its business. And here we tie these provisions up by saying that any failure to comply with these provisions would result in an event of default, which would enable the lenders to accelerate the funding and essentially call an event of default. And this places pressure on the borrower to ensure that its proverbial environmental house is in order, to ensure that no event of default will occur. Another type of provision in the first category includes placing obligations on borrowers to immediately notify lenders of any non-compliance with environmental laws or any potential environmental claims that may be made against them, so that lenders are placed with all the information at their disposal to identify risks as they arise and before they become losses, and potentially take action to mitigate or address those risks or require the borrowers to take corrective action to do so. Right, so the second category of provision we spoke about, that I mentioned, is a liability allocation provision. And essentially, this deals with a scenario where loss has already crystallized from an environmental perspective. And essentially, this deals as well with the risk that we've been discussing through the case law today, where the loss for an environmental harm has actually been placed at the door of the lender themselves. Is this a fair allocation of risk that lenders can accept? We're seeing a growing market practice that lenders actually include what we call an environmental indemnity in their funding agreements, which provides that should a lender suffer any loss as a result of the environmental actions of the borrower, then in such instances, the borrower would have to immediately indemnify and hold the lender harmless for such loss. And essentially what this does is places the responsibility for the loss squarely back on the shoulders of the borrower once again. As mentioned by my colleagues earlier in the presentation, we haven't seen these types of provisions being tested yet in our courts, but certainly this is the market, the market's response to allocation and managing of these risks at the moment. So yeah, in conclusion, that was a snippet of how these risks are practically being addressed by funders in the market, particularly funders to borrowers with environmentally risky businesses. And if I'm not mistaken, I think we are moving towards the end of our presentation, and I don't see that there are any questions in the chat box or in the question and answer block. So all that remains for me is to thank you all for joining us for another interesting installment of our ESG webinar series, and to invite you to please join us for the further topics that are going to be presented in the coming weeks. I believe that as we dial off this webinar, the further topics will be up on the screen, and you can email our marketing department should you wish to receive a link to any of those. So thanks so much for joining us. Have a good long weekend and go well.